Good morning. I'm Linda Morris. Welcome, everyone. Thank you for joining us today. Before I turn the podium to Joe, I want to address a few administrative details. Today's subject matter is complex, fairly dense, and likely to generate a few questions. To that end, we have index cards available to you to write your questions. We'll collect them, and the speaker will address them at the end here. The event is being taped, live streamed, and the recording will be available in a couple of days at the Vice Chancellor for Research Administration website. At the conclusion of the Q&A today, we need to wrap up quickly, tightly. Our speaker, John Preco, has another engagement in South Denver today with the Department of Homeland Security, and we mustn't detain him. So I hope you enjoyed the talk today, and I will turn the podium over to Joe Rosé. Many of you know, Associate Vice Chancellor for Research, Integrity, and Compliance.
Thank you, Linda, and my welcome as well. It's wonderful to see this group. We have a large group here. I see people from quite a few areas of CU, faculty, researchers, staff, a variety of departments. We have people here from School of Mines, we have people from Colorado State University, I believe on the online feed. We have additional folks, including folks from the University of Wyoming and a variety of agencies. So it's wonderful to see this level of interest. And I think the turnout is in part a reflection of our interest in the topic, but it's also a reflection of the very hard work that Linda Morris and her team has done. So I'd like to first say thank you very much for Linda and the rest of you for putting this together. This is really a wonderful resource for all of us. You know, it strikes me that for many of us, particularly the academics in the audience, there's been kind of an evolution of awareness about this topic of export controls. I think for many of us 10 years ago, we didn't know what the concept was. We never heard of it, or if we heard of it, we had no idea what the implications were. Then there came a time when we began to say, okay, I guess I see what it is, but it doesn't really affect universities, right? Everything we do is fundamental research, it's irrelevant. Then we began to figure out, okay, that's not quite true. It's more complex than that in fact does impact the kind of activities we do, but no one's really going to pay attention. We're a small fish in this game. It's all about industry. Why worry about that? Well, if there were any doubts about that, the case of Professor John Reece Roth brought those doubts to a sudden and rather dramatic head for many of us. So it clearly is a very important topic. For me, as Associate Vice Chancellor for Research, Integrity, and Compliance, I have my hands in all the various compliance areas on campus. And one thing that struck me is this is in many ways the most challenging, partly because it's complex. We have lots of regulations. Regulations are things that most of us didn't grow up with as academics. They are tricky to deal with. But even more fundamentally than that, I think, these regulations pose perhaps the most challenging conflict with many of our core academic values. I mean, for one, we all believe, I think, in academic freedom. And maybe more fundamentally, I think we believe that our role as a research university is not only to generate knowledge, but to disseminate that knowledge broadly and openly. At the same time, we recognize the importance of national security issues. We recognize the importance of economic security, economic well-being, and we recognize that sometimes our research impacts those national concerns. So trying to balance those core fundamental values as academics with our core interest in the welfare of the United States is a challenge. And we're very fortunate today to have John Preco here to help us wrestle that dilemma. Our speaker, John, is a recognized expert in the international trade compliance community. As noted here, he's president and managing partner of Trade Compliance Solutions, a network of professionals that works with major players in global trade to help them through a variety of issues. John has an interesting background. He actually has bachelor's degrees in both architecture and art design. He has a master's degree in counseling psychology, and most recently a master's degree in aviation management. Thinking of that mix may explain why he's been so successful, I think, in his last 15 years in working with all these groups on trade compliance issues. He's worked with the United States government, he's worked with industry, he's worked with law firms, and he's now, we're very appreciative of the fact he's making this outreach to higher education. Among his various affiliations, he's a member of the International Compliance Professionals Association, Society of International Affairs, and the Virginia D.C. Export Council. He's an accomplished author and a seasoned speaker. Today we're most fortunate to have him talk not only about the Roth case, but a little more broadly the implications of export control for higher education and academia. So please help me welcome John. Thanks very much.
Thank you for the gracious invitation, and it's my pleasure to be here. Some administrative notes. First of all, everybody should have copy slides, right? Along with that, you should have a one-page indictment summary of the Roth case. And the other thing I brought along, these are no cost, no obligation copies of something called the Export Practitioner. This happens to be the published version. It's also available online. But if you're in this business or related to this business, it's something you ought to take a look at. Just worth having, and certainly doesn't cost you a cent. You can't lose there. I'm going to change the rules a little bit from what Linda said, and it's only because of the nature of the audience. I started doing Roth presentations probably about 4 years ago, and it's evolved over time. And I learned that for most academic audiences, if I start with the Roth case up front, you're probably not going to have a great appreciation for some of the issues you need to know about foundational things. What are some of the policies? What are the players? How does the system work? So I now have about a dozen slides up front that will give you a fundamental basing on some of the complexities that we're alluding to. Some of it is very convoluted, many regulations. There are some simple things, and there are some very basic things I want you to take away today, and I'll emphasize those. I'm sort of very interactive and want to be engaging with the audience, so there's going to be times where I'm going to use you to make some points. Rather than hold your questions to the end, if there is anything you have a question on at any time during the presentation, ask me then. This area is fraught with acronyms. I'm sure it's just like what you do for a living. And chances are what the acronyms mean in your world are probably different than mine. So I will try and define them up front. But if you get confused, or if there's something I say that you don't clearly understand, stop me right then, because I guarantee you there's somebody else in the audience who probably has the exact same question you do. This is all in interest of outreach, education, and training, so you better understand the impact, the implications, some of the regulatory obligations, and some things you clearly do not want to do, and some other things you do want to do. All right? With that said, we'll get started. Now I'm going to talk initially about some of the key players in the equation, and I'm talking more broadly. I'm not just talking export controls, but I'm also talking trade compliance in the big picture perspective. These are some of the key U.S. government organizations that are involved here. If you're into the licensing and you're into the commercial and dual use side, a big player is the U.S. Department of Commerce. Underneath that is the Department of Defense. Anything that has implications as far as sensitivity, munitions, things that go bang, the Department of Defense is very interested in. And basically everything that comes from the Commerce Department with those kinds of sensitivities, and anything that applies to the State Department that deals with the munitions side of this equation, specifically defense articles and defense services, all play in this process. But there's a growing number of other organizations. Now, 2 years ago, in President Obama's State of the Union speech, he said there's about a dozen organizations that are involved in trade compliance and export controls. Well, that's not quite true. And the other problem here is, do all of these organizations have the same view of the world? All right? What is the State Department most interested in?
Foreign policy.
Foreign policy, okay. Diplomacy, all right. What about the Department of Commerce? Do they have the same perspective the State Department does? All right, so what are they interested in? Trade, right? Okay. They're very pro-trade and they're very customer-friendly. Now, what about our friends at the Department of Defense? What's their view of the world when it comes to technology transfer and things getting into the wrong hands? Paranoid, okay. Very protective, okay. Softer word. All right. Well, the other thing you got to understand is each one of these organizations all have a different set of regulations you have to abide by. And unfortunately, some of the organizations are better at education and training than others. If you've been in this business for a while, you know that if you call the State Department, you may or may not get somebody, and you may or may not get a return call. Very different culture at the Commerce Department. If you call them, they actually answer the phone and return phone calls. So not only are there different agencies, there are very different cultures you have to deal with. Now, one thing that's happened dramatically, specifically since 9/11, is the U.S. government agencies, particularly on the enforcement side, but across the board, are doing a better and better job of using technology and cooperating interagency. It's not perfect yet. The other thing you really need to understand is while the economy has some real serious issues, that the government, many people in the government think part of the solution here is throwing more money at enforcement. Put more people in jail, send the message so people will abide by the letter and spirit of the law. The point here is enforcement is invigorated. They're adding agents, they've got more people, they are looking for poster children. Dr. Roth is one of them. We'll talk more about him specifically and what's going on there. But is this the entire list of U.S. government agencies that are involved in this equation? What do you think? Not only no, but no way, all right? This is a partial list of some of the others. You know, lots of different perspectives here, and some of them have a significant amount of power in the equation. For instance, does Congress play in this at all? Absolutely. They basically own the cookie jar. And there are multiple committees on the Hill that have different parts and pieces of this equation. And again, each of these organizations have their own rules and regulations, and you have to follow them. And unfortunately, a lot of times they won't educate or train you. They're going to rely on you to figure out on your own. And if you get it right, that's great. If you get it wrong, you might have a visit you didn't want and have some new friends in enforcement that you didn't really want or need. One of my favorites here is the SEC, Securities and Exchange Commission. I found when I was with JP Morgan, working with CFOs, comptrollers, treasurers, etc., a great way into a company is with the people who own the money, because they very much understand the requirements and what happens if you get in trouble, you're under investigation, and there's some unique reporting requirements where they have to tell the government that they're under investigation far before you may even know about it in the real world. So there's lots and lots of stuff that you have to contend with to abide by the law. Now, this is a slide I actually used to use when I was traveling with the U.S. government. At one time, I was in the Department of Defense and in one of the key agencies that does export controls and licensing, called the Defense Technology Security Administration. I was the Deputy Director of Outreach and Government and Industry Relations there. And I used to travel around the country and around the world with the Deputy Secretary of, the Undersecretary of, blah, 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 and talking to audiences like Boeing, talking to different trade associations, and telling them about the system, and all in the interest of protecting technology, because we don't want, the good stuff, the high-end stuff, to get into the wrong hands. So the key players, the political appointees, really like this slide. It's very simple. I'll take you through it. You're the applicant. In this case, it's university, right? You've got a license that you need to submit to either the Commerce or State Department, and there's two tracks here. And one of the things I really need to clearly delineate is the difference between the two. State Department is actually pretty straightforward. They handle things that go bang, right? Or things that relate to things that go bang or explode or shoot or hurt people, right? On the other side, the Commerce Department handles something in this arena called dual-use items. And one of the questions I always get is, well, what does dual use mean? In my favorite, re-emphasized again most recently with the arrest in New York City, all right? Ammonium nitrate, all right? It's a dual-use item. What's the good use? Makes your grass green, right? What's the bad use? Okay, well, it was the major ingredient in the Oklahoma City bomb, and it was what the FBI sold to this guy in New York, who they arrested, who was trying to blow it up. So do you think the government is interested in who buys ammonium nitrate and how much they buy? Absolutely. In fact, one of my favorite stories that I always like to share is I was doing a C-level presentation, which is CFOs, CEOs, boards of directors, trustees, high-level folks in Houston, Texas, at a chemical company. And it was the CEO of the company and basically his different business units presidents. And some of the slides I'm showing you today are part of this 10 to 15-minute presentation. You take it through them. I get done, and he basically says, John, I really don't understand. We're only selling very small quantities of some of the sensitive materials that you're interested in to some of the countries that are prohibited or probably. Do you see anything wrong with that statement? He did not understand that the bad guys have figured out that they can't or won't come to his company and buy or try and purchase 4,000 pounds of ammonium nitrate, right? So what do the bad guys do? What do you think?
Make themselves.
Well, that's an option. But what they more likely do is they will go to, all right, we're looking for 4,000 pounds. We're going to go to 8,000 different companies, all right? And we're going to get a half pound from each of them over the entire world. Right? He didn't understand that small quantities, if you only look at it from your perspective, it may be insignificant or below the threshold of importance to you, but it may be huge to the proliferation network or the guy who's trying to build the bomb. So small quantities of important stuff make a huge bit of difference. So what happens is sensitive technologies, one of my favorites is night vision. You know, everybody in the government has interest in night vision devices. Well, why is that? What I say is night vision devices are more potentially threatening and more dangerous than a Patriot missile system. Okay, now why might I say that? What's the difference between the two? Well, the Patriot missile system is huge, right? Parts, pieces, components, missiles, all sorts of equipment. What about a generation 4 or 5 night vision device? Shoot, I might be able to stick that in a pocket or stick it in a briefcase or stick it in a box and take it with me overseas. And can one high-end night vision device be a threat to national security? Okay, in the hands of a tourist who wants to assassinate somebody? You bet. So everybody in the government wants to know what's happening with night vision devices. And there are some commodities, again, night vision is a good example, that belong to both the State Department and the Commerce Department. The high-end night vision devices, the ones that only our troops have, are under control of the U.S. State Department. And then there's another level of lesser capable devices that we will actually sell to some friendly countries. And then there's other items we won't sell to anybody, but then lower end night vision devices, generation 3 and beyond, are under the Commerce Department because there are valid dual uses of night vision devices. Like, any ideas? What can you use night vision devices for other than killing people? How about hunting, right? How about law enforcement? How about firefighting, right? So if you make night vision devices, you might actually have regulatory requirements under both regulations. And depending on what kind of research you're doing, okay, one of the first things you've got to figure out on day one is who owns the item, the technology, the service, whatever it is you're working on. And pretty much everything, except for a few items that fall under the Nuclear Regulatory Commission, fall under either the State Department in a basket on the U.S. munitions list where everything requires a license, or it falls under the Commerce Department where there are actually 2 baskets. One is the Commerce Control List, and the other one is everything else that is under Commerce Control that is called EAR 99 or No License Required, NLR 99. Now when I say everything, I mean everything, all right? And for example, I'm going to use you. What is this?
A pencil.
A pencil. What specifically? It's a number
It's a number
2 pencil.
sold at Office Depot.
Okay, all right. So, do you think this is an item that belongs under the State Department? Okay, the key questions what was the original design intent of the item? Okay, in this case, it was clearly commercial, right? Has it ever been, the next question is, has it ever been modified, adapted, configured, or changed in any way for military use? Well, in this case, no. But I am positive. There's no change been made to this item for military use. And what I just told you is incredibly important, all right? You can take a benign commercial item and make one change for a military use, and it's now controlled, instead of the Commerce Department, it's controlled in the State Department. I'll use one example. I used to do jurisdictional determinations for the government. And we'll say it's a benign mounting plate, 6 inches square. It's got a 3/4 inch hole in it for a bolt. Commercial off the shelf, available at Home Depot, Lowe's, everywhere. The US government comes and says, we want that mounting bracket, except we need to make that hole 7/8 of an inch because the bolt we want to put into it has to be ruggedized because it's got more requirements because of how we're going to use that. Guess what just happened? Okay, it went from the Commerce Department list. It's now been designed, developed, modified, or adapted, or configured, changed in some minor way for military use. Right? I'll show you some more examples of that, but you need to understand that. So one of the first questions you ask is, who does it belong to? All right? Again, this makes it simple, but okay, this is the slide I used when I was in the government. Well, things changed, and I moved over to industry and found out, well, it's not quite that simple, John. It's more like this. And what happens is, in this case, the University of Colorado's the little blue square up there, right? And they submit it through Linda, okay, to the appropriate agency, either Commerce Department or State Department. And then, if it's a sensitive technology, and I bet most of what you guys are working on, research and development-wise, by its nature, is what? Sensitive technology. So it gets staffed out. And this is where the acronym soup gets, okay? I'm not going to bog you down in all the names, but it goes to the State Department, it goes to the Defense Department, and then it goes out. And again, like a night vision device, it goes out to the Army, the Navy, the Air Force. Again, everybody wants to know what's going on with night vision devices. And part of the problem in the licensing process, one of the complexities that we're alluding to is, let's say for the sake of discussion, you've got 50 reviewers of a case. 49 of them say, we think this is a good idea, we approve it. The 50th one says, no, we have some concerns here because of national security. Right? What's your challenge now? You got to convince that one person it's okay. And generally speaking, if the answer is national security concerns, you're probably going to lose the argument, and it'll probably end up in the State Department by its nature. So there's a lot more to it. Now the other question is all of these organizations tied together by one seamless, transparent database? Okay, the people who are in this system go, you got to be kidding me. I'm convinced that at some point in time the government had every piece of hardware and software there was. Okay. The intent now with export control reform is to get everybody on the same database. But right now, a lot of this is still paper. Many of these agencies are not in the same place. They're across the country, basically. So that adds complexity to it as well. So there's a great deal to this. Each year, the Defense Security Service does an analysis of attempts to get technology from the United States by all available means. And what do you think is one of the, or maybe the top couple of ways, that the bad guys find out information about what you're doing? Internet. Okay, what else?
Literature.
Well, literature, right? Internet site. What about you get a phone call from a guy in Nigeria? Wants to know some information about your technology. But these are the ones.
I think a more relevant one is students.
So just asking questions?
Yeah, and they're foreign students, and they say, what you doing? Because I might want to come work.
Oh, good point. So can you tell them what you're doing?
Can I tell them what I'm doing?
Sure.
Here at the university? Sure.
In all cases?
So you're going to say, may I tell them, or can I tell them? Yes, can I tell them? May I tell them?
Maybe, maybe not, right?
Well, no, I'm quite sure there are quite a few things I can be arrested for already. Because I have an iPad and I travel with it foreign as a navigational instrument. So, no, I can't tell them everything in principle. But you asked how do we get information?
Yeah, and you're right. That's how they get information. We'll talk more about, and unfortunately the regulations are convoluted and confusing because under the State Department regulations, they use different terminology than the Commerce Department does. The State Department uses the terminology foreign person. Commerce Department uses foreign national, right? And the other thing we'll talk about later, but I'll mention it now because it's relevant to conversations with students or researchers, is not even the definition of exports is the same between those agencies, okay? The State Department has one overarching definition of exports. Basically, an export is anything, okay? Most people understand if I ship an export-controlled item from here to France, that's an export, right? But what people don't understand is if I take information, whether it's verbal or maybe it's a blueprint or technical data, etc., and I have a conversation with him, and he is a French citizen, what's happening? Okay, under the Commerce Department, it becomes a deemed export, meaning that I'm theoretically exporting the information to his country of origin. Yes, ma'am?
Doesn't it matter whether this person is a green card or not?
The distinction under the regulation is, are they a U.S. person or not? Part of the U.S. person definition is they are green card holder. Yes, it does. Makes a difference. Okay. The point being, the deemed export rule does not exist in the State Department. It only exists in the Commerce Department. And if you're like most academic institutions, you're probably doing stuff that falls under both the State Department and the Commerce Department. And you just have to be aware of the definitional differences in terminology and where you stand and what kind of jargon you're using, because you could get in trouble very quickly of being on the wrong sheet of music with definitions.
John, I just wanted to try and make a point on that, is that there is a difference between the definitions from the State Department and Commerce Department, but the State Department definition of an export includes the whole concept of a deemed export. It's not that it excludes
Right.
the concept. Right?
It's a more comprehensive definition. And one hopes with export control reform, one of the things they want to do in updating the regulations, which are, World War II style stuff, is to sort of harmonize. I mean, does it make it easier for you if there's more than one definition of export? No, absolutely not. But who's responsible for figuring this out? Well, the Commerce Department will tell you about their definitions, okay? But they won't necessarily talk to you about the difference between their definitions and the State Department definitions. Okay? So unfortunately, all that weight is pretty much on your shoulders and your export compliance professionals to make sure you get it right on the front end. Because if you don't, let's say, for example, you determine the jurisdiction to be under Commerce Department when in fact it was under the State Department. Right? And you thought you had a valid process, but you made a mistake. And what happens over time, generally when you get caught speeding, it used maybe be a customs person at a port of exit who says, wait a minute, you're saying that this is an ER item, but we think it's ITAR control, so we seize your goods. So you've got to get that right, because you could be multiplying violations. Other questions? So if you're on this list at all, you're especially of interest. We talked about jurisdiction and how important that is. And I'm going to use an example to talk about it. Again, generally, everything falls under these two regulatory regimes. And the State Department is the only organization that has the authority and responsibility to make a jurisdictional determination. Commerce Department can't do that. You go to Commerce for jurisdiction, they may tell you what the classification is, but they may get the jurisdiction wrong. I can cite you many cases of that happening. All right, the other thing we really need to talk about is sanctions, embargoes, etc. There are numerous lists out there of entities you can't do business with. This is one representative example of some of the countries. And the intent of this slide is to show you the differences between different agencies where countries are restricted by one, not by the other. There is some overlap, etc. But again, the responsibility is on your shoulder to check these lists that come out of the State Department, the Commerce Department, they come out of the Treasury Department, they come out of the United Nations. And now the problem is globally, many, many countries around the world are adopting the US sort of list insanity, where if you're exporting from the United States, you have to comply with all of our lists. But if you're importing into France, guess what? You got to comply with their list as well. And what happens here is if you do business with an entity who's on one of these lists, you risk being put on a list of some kind of restriction, prohibition, or you could be sanctioned for export controls. You could be debarred from government contracts. There's all sorts of onerous threats out there. Again, this is only representative. Now I'm going to regress a second. I sort of added this as a result of discussions yesterday. We're going to play kind of a game here. This is, again, to emphasize some of the jurisdiction and classification issues and how important that is. I got sort of 3 volunteers here. And what we're going to do is she's going to represent the Department of Commerce, right? We got the Department of Defense, and we got the Department of State. We have 2 items. And what we're going to do is we're going to explore these 2 items. I want you to just sort of look at them briefly. Now, this is an easy one, you know? And the question I'm going to ask, well, one, what do you think they are? And I'll open that to the group. The second one, and more importantly, is what is the difference between the 2 items? And then the third question is, what are the jurisdictions of the 2 items? Okay? you're a smart academic audience, right? You guys are well-versed, educated. This should be simple. So what do you think? What's the difference between the two? Obviously.
Could you speak up? It's really hard to hear people in the audience speaking.
All right. She says, obviously, the link. Your thoughts? Link, right?
Link seems to be the most obvious.
And any guesses by anybody on what are these things?
High pressure flow hoses,
Oh, close. High pressure
something.
hydraulic hoses.
Yeah.
Okay.
They're differently flexible.
Okay. That's not one of the differences, and the reason they're differently flexible is I try to put something in there to keep them straight, right? So that's my modification, right? So in this case, these two items are different, right? We agree on that. Now, the other thing you can't see that is different between the two items is the model and serial number between the two are different because they are different, all right? So the manufacturer can control these differently. So the difference is we've got basically something that's 7 3/8, and this is about 10 3/4 inches long. All right, so which one's commerce? Which one's what do you think?
Well, I guess it would all depend on whether it would be sufficient for it, like if it's more expensive, it would modify.
Okay,
or help
okay.
the original purpose.
It depends and what change was made, all right? Good point, all right? Any other thoughts?
Is one of them standard and one of them non-standard production product?
Okay, a relevant question for the discussion, all right? Now, what really happened here, and you got to think about when the military is doing something, let's say we're building a Apache helicopter. And we are concerned about some things in the manufacture of the helicopter that may not be a concern to the same degree of somebody in the commercial marketplace. For instance, size and weight, right? We got to get more stuff into a smaller space. So, well, what happened here, John? Well, what happened here is the Department of Defense, specifically Headquarters United States Army, went to the commercial manufacturer of a commercial helicopter and said, we want this hose, but we want to make one change to it. Okay? And the one change was the length. So this item is controlled under the Commerce Department, and it's actually on the Commerce Control List. It's a controlled item in Commerce. But now this item is controlled by the U.S. State Department as a Category 8H item. Now the good news is with export control reform, there are many parts, pieces, components like these that are moving from the State Department to the Commerce Department. This is one of them. In the future, theoretically, if this happens as sort of broadcast, this item will become a Commerce Control item. But it's still going to require a license, right? You're still going to have to submit paperwork. You still need approval. You're still going to need safeguards, access controls, all of those things that involve foreign students and foreign nationals, okay? Again, that's an important point, and that's where your export control experts come into play early on when you're doing research, unfunded or funded, and you're starting to do something that has some kind of sensitivity to it.
What is it about those that makes them so important technologically?
Oh, technologically? Oh, that's a good question. Well, currently, the problem is the regulations now state, the two questions I asked you that were the first two questions on the checklist that we use in the government to make determinations, i.e., question one is original design intent, okay? The original design intent was commercial, okay? Second question is, has it ever been modified, adapted, configured, or changed for military use? It was, okay? So under the current regulation, benign stuff, now, what's the military criticality of this? Okay, well, it could be to the point where, let's say, Iran had this helicopter, and this was a needed piece, and they wanted to get it, okay? One of my favorite cases, this was a family of rivets, okay? This was a commodity jurisdiction request that was submitted to the State Department. I was in Headquarters Army, and I staffed, worked all of the jurisdictional requests. 17 rivets, okay? 16 of the rivets, every one of them different in some minor way, were all on commercial aircraft. The 17th rivet, again, different than the other 16, was on the F-14, all right? Well, not only military, but who owns F-14? Iran, all right? So are we controlling rivets currently? Yes, we are, okay? And a lot of these items that are going to move, the government wants to move all these items in just sort of one mass thing. But there are some items, like that rivet, where that may not be a good idea. But the point being is we're controlling small stuff. And what is that? Look at the wiring diagram I showed you. If you get a license for a rivet, you got to staff it, right? So it involves agencies, involves people, involves time, all sorts of stuff. That's a reason why this export control thing is important, because of the movement. Although I'm not convinced yet about how much paperwork we're going to save. But you're still going to have regulatory requirements. You just can't get away from that, unfortunately. All right, so we've got country list that you're concerned about, okay? And for you, country list translates to what? Foreign students, right? If you've got a foreign student from a sanctioned entity like Iran, North Korea, Cuba, and others, you may not be able to even have that conversation because of the export controls on that technology. You may not even be able to talk about it, okay? And just remember, the medium doesn't matter when you're talking exports. I don't care whether it's a conversation, it's an email, it's a fax, it's a telephone discussion. Whatever it is, the rules apply, all right? If the information, in whatever form it's in, is export controlled, and you don't have a license to share it with that entity, the deemed export part of the equation, somebody from a foreign country, then you have violated at least one of the regulations, and maybe two, depending on where the technology falls as far as jurisdiction. Does it complicate that for you? Absolutely, right? Because you've got, how many foreign students do you have? Foreign nationals, foreign persons, whatever. There's two definitions there. Right here, right now, at Colorado State University, or at whatever institution you're working at. And chances are you got a lot of them, because technical expertise, resident technical expertise, interest, and just knowledge and intelligence, there's more people from outside the U.S. than inside the U.S., and it's part of the issue that you have to deal with. So talking about those issues early on about where are they from and what's the technology, and do we need a license, or do we need some kind of technical assistance agreement just to be able to talk about or provide assistance or do research on this subject, are all very viable questions as early as possible as you can. Now, it's not just countries that we're worried about here, because there is a proliferation of these lists. There are literally thousands of entities on this list. Countries, companies, individuals, okay? Now here's some of the best practices that certainly pertain to you. I'll let you do a little reading here.
How does this apply to students?
Well, you tell me. Did you read the whole thing?
Yeah,
Okay, do students fall in here anywhere?
many places.
Okay, absolutely.
So, who is responsible? The university who admits the students? Or me who is thinking of hiring students, but they're already admitted?
My answer is yes and yes. I mean, you should have some kind of procedures in place to do this.
So I don't think there are any procedures for studying whether, other than maybe background checks. We have, as far as I know, we have students from several of those countries on the previous list, and they're admitted.
Mm-hmm. So in my world, as part of your admissions process, you could theoretically check them, all right? There's no requirement there because you're not worried about export-controlled information, right?
So why is that? Once they're here.
Once they're here, okay.
Exposed to export control.
And one of the questions I used to ask entities about who do you screen? I now ask who do you not screen, because it's a much smaller subset. The people you have to screen are those where export control are they a foreign person, is there export control information involved? However, I do know entities who before they hire somebody, they're screened. Okay? And that could apply here, but more important to you is before you bring on the Iranian student to the research project that you're working on or involved with that is under the ITAR or the EAR, you definitely should screen them to make sure that they're not on a list, or if they happen to be a citizen of a country that is prohibited, and particularly under the State Department. Let's say you've got an Iranian citizen, and you're doing ITAR control work. the answer would be no from the government.
But this is what I don't understand. I'm not talking necessarily about hiring. Suppose they're taking a class.
Whether, is there any export control information involved?
Oh, very likely. If they're taking a technical class, almost certainly. They learn about microscopes, they might learn about navigational systems, they might learn about night vision goggles, all kinds of things.
Well, and it depends a lot on, I'll call it degree of sensitivity. If everything they're talking about in the classroom is in the public domain, all right, then you probably don't have an issue. But what you need to have is a system in-house that makes it, you step A, step B, okay? Do you want to screen all students coming in? That's an option. That's a business decision. Do you only want to screen students who are going to classified research or export control research? There's a place where you've got to make a minimum standard, and you've got to ensure for your own well-being and to comply with the regulations that they're not on the list, right? Does that make sense?
It's not practical. I mean, the university admits them in, they come to my class. I'm not actually choosing whether they sit in my class.
Well,
Yeah.
the university enjoys an education exclusion, and if
Use the microphone, Linda. Can't hear a thing you're saying.
Okay. Okay, well, we would be, in your case, we'd be talking about the education exclusion. And if your course is a published course in the course catalog, you're not inserting your research that might be export controlled into the course, then your foreign student is free to enjoy that course. Where you're going to run into trouble is when you have a research project and you're hiring a foreign national, foreign student on that project, depending on what that project is and if there's export controls involved. That's where we get inserted into the equation and start working with you on the technology control.
When the government would ask you, what methodical, consistent procedure do you have in place that you follow here? Whatever you decide, in industry, it's gotten to the point where the only people you don't have to really check for a list is somebody, if you're doing business with the United States Air Force and it's, Lieutenant Smith at SAF IA, then you don't have to check the list. But, things like who's on your cleaning crew who comes in at night and looks at your tables or looks at your lab research? What do you leave out? I mean, it's gotten to the point in industry that they check everybody. If a visitor arrives at the door, they don't know who it is, they get screened. An employee applies to work at the company, they get screened. And part of the problem is do the bad guys tell the whole truth and nothing but the truth when they're trying to find out something they shouldn't find out? When they're trying to get a job into a sensitive technology where mother country is doing research and they want the leading edge stuff? Truth is not part of the equation. Yes, ma'am.
One thing I was going to say is NASA, DOD, right now are actually requiring you to screen all of your subcontractors, regardless of the U.S. company or not, and the key people that are on those subcontractors. And they want them screened at proposal, they want them screened at award, and then they want them screened again on an annual basis.
Right.
So they're looking for your screening not only once, but 3 times.
Two good points you make. Basically, all the primes I know of, Boeing, Raytheon, all the big folks, out of fear and paranoia and having been indicted, convicted, and settled with the government on issues like this, are now trying to take some of the weight off of their shoulders and going down to the 2nd, 3rd, 4th tier contractors and getting stipulations from them that they have screened, that it's ITAR, whether it's ER, et cetera. The other thing, your point is very important, is screening is not something that happens once, all right? The government tells you that you screen every party to a transaction at those points where something changes. So immediately when you know who the student is, and they're going to work on a classified contract that is ITAR controlled, screen them, all right? Well, if something changes, in the industry world, say we're shipping some products to France and we change our freight forwarder, well, we need to check again, okay? And we need to also check before we make shipments, because this proliferation of lists are dynamic. Some of these lists change every day. I used to, one of my favorite questions, and we did this at the seminar yesterday, do you screen and how do you screen? It used to be you could screen manually, maybe, 5, 10 years ago. Now, because we're talking thousands of entities and lists, the only way you can screen is an electronic database, which you've got, but you need to have all the procedures in place to make sure you use that at the appropriate times in the equation that you need to for your own self-protection and to comply with the regulations. Point well taken. Thank you. Okay? So we said, all right, here's some of the best practices. Now this is sort of a phase test. Who are these entities? What do they have in common? All right? Now how do they look? Do you see any sort of foreign things here? Anything stick out to you as a foreign entity in any way? All right? Now all of these are U.S. persons, or the entity is U.S. incorporated. However, they either are or were on the State Department's debarred list, which means you can't do business with them as far as export controls and technology. So don't be, one of the things I always get is, well, John, wait a minute, you're talking about a lot of time and effort, and gosh, we got to do this multiple times, and we're doing business with Joe Smith in Poughkeepsie, New York. How can that be a problem? Well, these entities are U.S. people. So don't get misled that just because they're a U.S. person or even a U.S. student, that they may not be on the list. And the only way you can do that is you got to check the list by some means. Now there are some sort of very rigorous requirements under the law. Federal sentencing guidelines pretty much tell senior leadership, whether it's a board of directors or trustees or regents, whatever you've got, have some responsibilities. They have to do this by law, okay? They got to know what's going on. You've got to have the people, you've got to have the software, you've got to have the stuff you need to get the job done. And there pretty much has to be an open door policy between the compliance and export controls experts in the field and senior leadership, whether it's the vice president of compliance or it's the president of the university or those kinds of things. Because if you get in trouble in this area, and generally speaking, when you get in trouble, it's not just one violation. By the time you discover it, yeah, we've done this 25 times. So senior leadership really needs to know what's going on. So what do you think the answer is to the last question here?
Let me ask a question of Linda and Joe. Have our regents been briefed on this slide?
Our regents are, they are on record with the Department of, with the Defense Trade Controls, registered export compliance.
Do they know and understand?
I believe they've been informed.
Not so.
So how do you think the government figures out whether the Board of Trustees or the Board of Regents knows what they're doing or is complying with what the sentencing guidelines say? How do senior leadership do business, right? They have a meeting. What comes out of the meeting? Minutes of the meeting. So what does the government do? They subpoena the minutes to the meeting, right? So they can very quickly figure out whether the regents, are they informed or do they really know what's going on? And I guarantee you enforcement agents aren't reluctant to start asking questions. Well, we've informed them. Well, do they know what they're, and this applies to industry as well. Does your CEO know the law? Are they directly involved? Do they know the consequences? Do they know you're under investigation? Or, some important issues here. So, and it doesn't take the government any time at all to figure out what's Memorex and what's really going on. All right, this is one of my favorite slides. This is from some of the C-level presentations I do. And it takes one example. This one happens to be under the Department of Treasury, but it applies more broadly in some of the things that you need to take away from the experience, basically. And a lot of this has changed over time. It used to be that you made a violation under the Office of Foreign Assets Control, or also in this case under the Department of Commerce, because the fines were the same. One violation was $11,000. Okay? In industry, $11,000 wasn't a whole lot of money. All right? Some of the huge fines, even the ITT case, which was the biggest Department of Justice fine to a defense contractor, was $100 million. But the $100 million is not what got ITT's attention, because that was like, I think we figured it out, was like 1.2% of their revenue for the year. What gets an entity's attention when it comes to complying with the law? Well, you threaten them with fines and other sanctions. Okay, you could be put on the list. You could be debarred. You could lose all sorts of things. But what happened is over the last few years, again, thanks to our friends on the Hill, with the concept of, all right, we're just going to increase the fines. We're going to make the fines bigger and bigger. Therefore, the poster children are going to be the deterrent to stop people from breaking the law. Really hasn't worked if you look at what's going on in enforcement cases. But what's happened? Even over a 3-year period, something that would have been a $500,000 fine now suddenly is $12.5 million. Well, and the other part of this equation is under the State Department, you just double everything here. Right? More sensitivities, more damage, etc. So there is a lot at risk from that standpoint, and it could be very costly. But again, it's not the money that gets people's attention. It's the other things we'll talk about here shortly. All right. This is kind of the end of the lead-in slides. These are some of the bad things that can happen to you. We've talked about some of them. What do you think is the most onerous threat to either a corporation or, let's say, an academic institution? What big hammer does the government have that would dramatically impact what you're doing?
The second one.
Yeah, actually the first two. Okay, and you got to remember that export privileges are a privilege. You don't have a right to export. All right.
We only export information in scientific meetings and so on.
So?
But we can't do business without the second one. We're cooked.
Right. Yeah, from your perspective. Right. And the government has the ability, even during an investigation, to do that. And I was involved in a case where the government was not happy with the lack of cooperation they were getting from the entity. And they said, okay, until you start doing and cooperating the way we think you ought to, you are now debarred from both government contracting and exports. And this was a major defense contractor, and we're talking thousands of DSP-5s and technical assistance agreements and things in the pipeline that suddenly stopped. So it's a huge hammer. Now what about, go ahead.
Well, I have a question. Did their customers in the U.S., which presumably were the Air Force and the Army who stopped getting their deliveries, what happened with them?
With the customers?
Yeah, with the U.S. customers, legitimate customers of, say, big company, Northrop,
right.
Right down, you said, okay, you can't export anymore, and you have no U.S. government contracts. You say, okay, I just won't deliver to the Army, who's right now in Afghanistan or whatever, and are desperate for our products.
Well, in this case,
what happens with it? With
good question. In this case, what the State Department and the enforcement guys did is they did a carve-out that said, okay, let's say night vision devices, we've just sanctioned you because of your lack of cooperation, but the Army needs these devices. So we're going to approve this specific set of licenses because we're not going to hinder our national security or hinder the military. I mean, they have infinite latitude on how they want to structure this. They can stop you from doing 75% of it, but if the Air Force, the Army, the Navy, some military service needs what you've got, and it's being used right now in Iraq or Afghanistan, they'll make sure they create a way to do that administratively.
Even if the company says, well, no, we're not going to do it.
Well, then they suffer all sorts of legal implications and go to court and all sorts of other stuff.
Default.
All sorts of bad stuff, and it ripples because one of the big threats to a major corporation like the one I'm talking about is shareholders. We're going to have a shareholder lawsuit against the corporation because of stuff like this. It can get really ugly from this standpoint. Now, what about the individual? What's the big threat to the individual? And when individual we're talking about theoretically could be you, right? Individual. Let's say you have knowledge that you have an Iranian citizen working on an ITAR control product, right? What's the worst thing that could happen to you? Kind of obvious, right? Well, you can lose your job, right? Because there's guidance in writing from the institution that says you can't do that, right? We're going to talk about a case where that's inherently obvious. Or the school could also suffer. The school could be, depending on what they did and who knew what. The questions, I've done a lot with enforcement. In fact, I testified at 2 grand juries for criminal investigations and export controls. There are 4 questions you will get asked in an investigation. If you happen to be involved in a investigation, you get the opportunity to sit down with 2 enforcement agents, both who have badges and guns. They read you your rights, basically. And let's say something is under investigation and you're part of it, all right? They will ask you 4 questions. I guarantee it. I've seen it on both sides, helping enforcement and being involved in an investigation of a company. So I know this is true. First question is, what did you know? Second question, when did you know it? Third question, what did you do about it? And the all-important fourth question is, what documented evidence do you have that proves what you just told me? And how, depending on how you answer those questions, you can be sort of off the hook, or now you may be a target of the investigation. So yeah, the company, the institution has exposure, liability, and risk, as does the individual. And one of the things about, you got to understand there's a huge difference when you go from a benign civil action, okay? Let's say you did something inadvertently, I made a mistake, I didn't know about this ITAR thing, and we made a mistake, we report it to the State Department, we take corrective action, it doesn't happen again. Okay, slap on the wrist. Well, no. This is a case where you knew what you were doing, and you willfully continued to do it. So now you move from a benign civil case, now you're talking about real bad stuff. And if you really want to multiply in there, is it a national security item? Is it something that's more sensitive? Is it the high-end night vision stuff? Is it going to, is it nuclear triggers to Iran, or is it number 2 pencils to Cuba? The specifics of the circumstance make a huge difference in the outcome of the case. The point being there is organizational and individual culpability without any doubt. What do I do with my clicker here? All right. All right, so with that as an underpinning, we're going to talk a little bit about the Roth case. And I personally want to thank several people in this equation who I've worked with. I really started getting involved in this probably 5 years ago when I was interesting, the dramatic difference in talking to academic institutions before the Roth case and after the Roth case. Because before that, the response I got was, hey, we're below the radar screen, nobody cares. There was a Department of Commerce case 15 years ago, a Dr. Butler, University of Texas, bubonic plague to the Tanzania, I think. Ended up getting fined. He was debarred for 4 years, went to jail, basically. Right? But there was nothing on the State Department side. Now there is. Okay, it's huge from the standpoint of, boy, it got everybody's attention very quickly. So now there is at least a sensitivity that there is a reason, not only from a regulatory standpoint, but it's a lot easier when you can point to a case and say, here's what can happen to you. Because as we speak, the doctor is in jail. Right? We'll talk more about that. Two people I worked with early on. Robin Witherspoon was the export control officer at the University of Tennessee. Super lady. She is now, I think, out on her own and helped form something called the Association of University Export Compliance Officers. Because one of the complaints the academic institutions had is nobody was educating, training, or telling them really what was going on. And it was one of those where, hey, not our responsibility, you figure it out, you get it right, fine, if you don't, you're in trouble. So the other ones were the two U.S. attorneys who were very helpful on an ongoing basis of telling me a lot about, you're probably smart enough to know that certainly when the government puts out press releases, it sort of paints the government's view of the world, right? It doesn't give you all the background, but these two guys were especially helpful in providing some of the essential background information. Oops, somehow I want to use the right side. Up. Okay, do we have the same problem we had before? I bet. Ah, all right. Important part of this equation is when you get into a situation that has the national security implications, that has the knowing, willful, all the bad connotations to it, suddenly it's not just one government agency who is involved. Now what happened here is the University of Tennessee actually ended up voluntarily disclosing to both the FBI and the State Department what Dr. Roth was doing. And the reason he did that is because he was told that what he was doing was not in accordance with the law. He was told what he could do and what he couldn't do, and he chose to do what he wanted to do. All right? So it got real interesting real fast. And you got to understand, cases like this play out over a long period of time. The actual specifics, I think, took place 2005, 2006. He was indicted and sentenced in 2009, and he went to jail in January of this year. Okay, we'll talk more about how that transpired. But the important part is, boy, there were a lot of people who played in this equation from day one. One of the things I've seen since I mentioned earlier about since 9/11, the enforcement guys are really working together more and more, and certainly more interested in what academia is doing or not doing in a very different way than they used to. All right, for some reason. So here's what sort of happened. Here's how it began, at least from the public side of the equation. Dr. Roth was working on technology having to do with the UAV. That did a lot with how the wing was configured, etc. He was basically he was the expert in the field, basically, world-renowned. Here's some of the statements the government made in the context of sentencing and the case itself. Highlight the words knowingly, okay? To me, knowledge is like toothpaste. You know, once it's out of the tube, it's a little hard to shove back in there. And as soon as you know something, you have an obligation. Now, my contention is you're either part of the problem or part of the solution, right? So if you know something's going on, you have a decision to make. You know, do you do something about it? Do you advise the right people? Do you make sure you're on the right sheet of music in accordance with the regulations, or do you just sort of continue business as usual? Now, I'm not big on reading slides, but that last sentence, our scientific and educational communities must take precautions to ensure that technology and research are protected. Is this optional? You got to question the government's spelling check, but that's okay. Insure instead of insure, right? I caught that. So you don't have the option not to do this, right? Sounds pretty clear cut from at least the government standpoint. Now here's the actual charges against the good Dr. Roth and his counterpart, Daniel Sherman. They were in business together in a company called Atmospheric Glow Technologies. And they happened to pick a very sensitive technology, and they happened to pick, you know, if you're going to pick them, let's pick the great countries. Let's export prohibited items to both China and Iran, which are in themselves prohibited countries. So there was a lot up against him. I actually pulled the stock ticker off of AGT when it was still up and running, and you can see the impact that had on the entity that eventually declared bankruptcy. Very real consequence. Okay, a quiz here, kind of to see if you're coherent. What do you think? How many? One. Absolutely one. And worse yet is, generally speaking, any entity that is registered with the State Department, it's registered as a single entity. Okay, if you're the Boeing company, each one of your business units isn't registered with the State Department. You, Boeing, are registered. So if Boeing Commercial Aircraft gets fined, indicted, and convicted for wrongdoing, does that impact the entire corporation? Okay? University of Colorado, you're registered with the State Department as an entity. So if one person in the room, or one institute, or one business unit, or one researcher does wrong, who suffers? We all do, right? It impacts, we talked about what bad things can happen to you. So there's lots at risk, basically. Since the clicker's not working, be flexible. All right. Documentation can either work for you or against you. These are some of Dr. Roth's notes. Now, Dr. Roth claimed that he didn't know, he didn't understand. It was confusing. There wasn't anything in writing. However, there was quite a bit in writing that told him what he should have known. Okay, not only his notes, but the actual contracting documents.
Can you go back to that other slide, please?
Sure. I think I can.
And this is a statement of work to whom?
These were just his notes, his individual personal notes, as a result of a conversation as part of the contracting discussions. Okay? Now, I got to tell you, too, the other guy in this equation, this Daniel Sherman, when they sort of got caught speeding here, they both got separate lawyers. They both took very different paths here. And I will tell you, I've talked to quite a few agents who were involved in the case. And unanimously and consistently, they all describe Dr. Roth the same. Arrogant, condescending, and above the law. He was very vocal in places like the school cafeteria saying, here's what I'm doing, and I really don't care about what the government, the rules don't apply to me. Not a good position to be in. And he never changed his tone from day one. However, his counterpart, who also was indicted, had a different law firm, a different lawyer, and was very conciliatory, and basically dealt with the government and turned over a lot of the documented evidence to the government to put Dr. Roth in jail. All right? And again, the other part of the equation and the question I asked you about one person being, all it takes is one person. I'm not aware of any situation in industry, government, anywhere, where one person in an organization and only one person was responsible. This is too hard to do with just one person. The worst case is if you have senior leadership, a manager or somebody else who is willing to sort of overlook wrongdoing or disregard or just forget about it. It takes more than one person because it involves usually several people to do that. So, all right, so that's that piece. And the other piece of documented evidence, there was much more than this. I just used these as illustrative examples. Now, in the midst of all this, their export control administrator, Robert Witherspoon, Dr. Roth decided he was going to take a trip to China. I think, oh, I'm sorry, wait a minute.
I don't understand why the company AGT got in trouble over this. If he signs in the contract that he won't export the information on what he bought, but then he still does, why is that conspiracy with the company?
Well, AGT was co-owned by this guy in Roth. There's more on. Hold your question. If you still have it at the end after we deal with some of the other issues, come back to that one, okay? The other thing is that Dr. Roth was going, I think he was going to China to speak at some kind of symposium or conference, and wanted to take his laptop and he wanted to take notes on some of what he was doing with him, okay? It was clearly explained to him by the export administrator, you can't do that, you can't take your laptop with that information on it, et cetera, et cetera. Well, he went anyway, okay? He took his laptop, and while he was in China, he also had his research assistants back in the US email information, both in attachments and emails, of technology, ITAR-controlled technical data, information, et cetera, to Chinese nationals on the other end. When
Chinese or to him? Just not that it makes a big difference. But
well, it went to China. And I think one of the emails actually went to a researcher in China who was a Chinese foreign person. Dr. Roth, when he came back into the country, his laptop was seized, okay? They took it, and some of the proof, you know, he had stuff he wasn't supposed to have. And this is a whole other area that you'd have to talk to your folks about when you're traveling internationally with laptops. Because there's all sorts of impact and implications. What's on your laptops? In industry, what's happening now is they have, I'll just call them clean laptops, right? That if you're going to go travel around the world somewhere, you take a laptop where all this stuff has been taken off. Because you not only have to worry about what's on the laptop, you have to worry about the Commerce Department rules and encryption rules and other rules of both here in this country and that country. So depending on what level of encryption you have on your laptop, you may or may not be able to take it to another country, okay? What is the capability of the laptop? Because there are tiered controls about who gets what in what country. So there's all sorts of ways to do this, but you've got to do it. You know, having what you need to have when you're traveling internationally is nice. However, you got to abide by the rules, and the rules are very different under the State Department as far as how you control that information if you do take it versus the Commerce Department. Again, it's the anomalies between the government agencies, but you certainly have obligations there. Yes, ma'am.
What about smartphones?
Great question. Right now, the regulations don't do a good job of talking about that, but the same rules apply. You know, is there encryption? What's on the hard drive? What information? The bottom line is, I don't care whether it's an iPad or iPhone or whatever it is, if you have export controlled technology on there and you're carrying it, you got obligations under the law. And you should have procedures to cover that as well. It's not just laptops. Unfortunately, the regulations, they're so outdated that they don't cover a lot of the high-end technology stuff that now exists. So again, it's left up to you. To me, I look at a laptop and an iPhone, as far as I'm concerned, hey, I can't do that here and I can't do that there. So again, the medium doesn't matter. You just have to comply with the rules of what you're putting on there, the technology, et cetera. Does that make sense?
Well, it's like they have gyros. They're navigational instruments these days.
Or are they export controlled?
Pardon me?
Are they export?
I mean, navigational instruments are export controlled.
Right.
They have navigational devices on them. So taking them to another country sounds like you're already violating it.
You may be, but you have to check the regulations to see if it's on, is it on the State Department list? It may be on the Commerce list, or it may be EAR 99, where it just depends on, well, what country you're taking to. You might be able to take it to some countries and not be able to take it to others. Like I said, this is not, we're not talking simple here. This is complicated, convoluted. Everything you said is absolutely on target, but it's not my responsibility or the government's responsibility to educate and train you on what you're doing right and wrong. It's unfortunately your responsibility. Unfortunately, the government doesn't consistently do a great job. Commerce Department does. I bet you have Commerce Department seminars and workshops right here in Denver that anybody in this room can attend. Now, I'm not an advocate of making everybody in this room an expert, all right? All you need to know is, okay, ask some questions early on in the process and get with your experts. Look at screening, look at denied parties, what's the technology, what's the jurisdiction? Answer those basic questions. The sooner you do that, the better off you're going to be, because this is, nothing in this part of the arena gets, it's not like fine wine, right? It doesn't get better with age. If you're violating the law and you're sort of, well, we're looking into it. Well, if you're looking into it and you're still violating the law, then you're just multiplying problems. You've got to do something fairly quickly. You've got to be proactive in abiding by the letter and spirit of the law. So, documentation. You know, documentation is either going to work for you or against you. You know, if you claim you didn't know and the documentation says you did know, what do you think the government's going to do? Well, they're probably not going to believe you, and particularly with an attitude that's described with Dr. Roth. You know, certainly not cooperative. You think that energizes enforcement agents when they see that? You know, you bet. All right, now this is how bad it could have been from the government standpoint. This is what he could have gotten for all the counts and all the charges. Pretty big bottom line, right? And you got to remember, when he started this, I think he was like 70, late 60s. I think he's 74 now. And he's got serious medical issues. There's lots of complications to this. But what did he really get? What happened here? Well, to determine what he really got, there are a lot of factors. We talked about the sentencing guidelines. Judges in these cases have almost infinite latitude to consider some guidelines the sentencing guides give you on how many, what's the fine, how many charges, etc. But according to the U.S. attorneys in Knoxville, these are some of the specific issues that the judge considered in making a final determination on what Dr. Roth got. Some of them worked for him, some of them worked very much against him. And again, he didn't help himself at all from day one. So this is what he got. Now, when I talk to people in industry, okay, you know, the Boeings, the Raytheons, etc., they said, oh, he got off light. Because ultimately, what did he end up with? 4 years in jail. That will actually probably only be 2 years in jail because of the medical situation and some other mitigating factors. But he didn't get fined, okay? Well, but what you don't know is Dr. Roth doesn't have his, instead of being on the beach, you know, in South Carolina enjoying his retirement, he has no retirement funds, okay? He spent it all, basically, fighting the case. And now he's in jail, right? Not something to look forward to at all. So in one sense, you might say it was light. In another sense, it certainly got the message across and has become kind of the bellwether case for academia on ways not to do business. Now, he tried to take his case all the way to the Supreme Court. Never quite got there. He submitted a writ of Centauri, I think it is, for the Supreme Court to hear his case. The court looked at it and said, nope, we're happy with the lower court's decision. We're not even going to hear the case. And so that basically closed the door. And again, I point you to the last sentence in this one as well. Underscores the criminal consequences of noncompliance and what happens to those who knowingly and willfully violate export control laws. Yes, ma'am.
Okay, so I'm having a hard time with the knowingly part, because my understanding of the ITAR is that ignorance isn't bliss, in the sense that the exporter of record is still responsible for following laws, even if they don't know them.
Right.
And so the knowingly, in a sense, just makes the sentencing more dramatic. But the not knowing would not have been a legitimate excuse for him to avoid any.
It would, I'll mediate that a little bit. It would not have been an excuse for the institution. It could have been an excuse for him. Had he not known, had he not been educated, trained, told point blank that he couldn't do stuff, it could have been a different story.
He still didn't adhere to the regulations.
Oh, no. In fact, I did one of these presentations previously where somebody said, well, if Dr. Roth would have just submitted an export license to the State Department, this wouldn't have been a problem. Well, that's not even close, because the technology and the countries he was working with are prohibited. You can't even talk about ITAR controlled stuff for people in that country. But there is an obligation on the part of the organization, again, whether it's industry or the academic institution, to educate and train you.
What you're suggesting is that faculty at the university here should make a point of not attending training sessions.
Well, that sounds like to me knowingly avoiding. You think that's a factor that would help you out if something went wrong? But I've seen that before. I saw it in industry where guys in business development, every year I would do training at the company, and every year Sam was just not there. You know? He wanted to play by his own rules, etc. Well, that becomes a problem for the organization, because Sam may be able to please, well, I didn't, you know, I never got the training, I didn't know what was going on. Well, then it falls on the company's shoulder. Now, in the Roth case, did the University of Tennessee pay a fine? No. Well, why is that? Well, the University of Tennessee cooperated. They basically ratted the doctor out to the government. You know, they did the right things. They took corrective action so it doesn't happen. You know, they were team players. But I do know of cases in academia where the institution knows that something's going on and they still haven't done something about it. Again, time here does not help them out, particularly this is a case that they've been doing it for more than 2 years and haven't stopped doing it, even though they know that it's wrong. I mean, one of my favorite, it goes back to one of my favorite questions during these C-level presentations I used to give. This was a CEO who basically said after the presentation, well, what's the big deal? What if we just continue doing this? Well, that's when you have this discussion about going from a benign civil penalty to you got criminal intent. You are knowingly, willfully, you know you're breaking the law and you're going to continue to do it. The point from your question is the institution has an obligation to train you. And if you're a professional in what you're doing, I suspect that you probably have an obligation to attend whatever the appropriate training is based on what you do for a living, what's the sensitivity of the technology, do you ITAR, do you do EAR, how much training do you need, all those kinds of questions. But those are all internal questions. You need to know enough to ask the questions to say, oh, red flag, go talk to Linda. Or go talk to whoever your representative who knows who's the expert in this arena. Just know enough of the basics to be able to do that. Does that sort of answer the question, or not really? You're responsible, you the individual are responsible, and so is the institution. That's the best answer to the question I can give. Anybody want to talk to Dr. Roth? Here's his address. Right? You can. I got a call 2 weeks ago from a guy.
Does he do emails?
I don't know. I got a guy, what was his name? Dan Golden. He's a writer for Bloomberg Press. He found my name on the internet, wanted to know what I was doing with academia, and he was going to actually interview Dr. Roth last week. In fact, I said, ooh, here's some questions I like answered, you know, in hindsight, you know, knowing what you know now, what would you have done differently? I mean, I had all sorts of questions for him because he has been depicted as such a kind of a bad actor, but maybe his attitude has changed. I don't know. I'm very interested in the outcome of the interview. This is the other guy in the case who cooperated with the government. He actually served his time in jail and was out of jail before Roth went to jail. But again, a whole different He and the law firm he worked with took a whole different perspective in how they talked to, cooperated with the government. He changed gears because when he started out with the same attitude that Roth has, but came around. All right, important part of the question for takeaways. Enforcement's relentless, particularly if you're willfully violating the law. You guys are part of the equation. As far as the regulations are concerned, it doesn't matter whether you're in the US government, whether you're in academia, whether you're a research lab, whether you're a federally funded research and development center, or whether you're a company. The rules apply, right? What you got to do is figure out how to work within the bounds of the rules with all the complexities of what you do and kind of put them together in some way that abides by the letter and spirit of the law. I always love talking to academia because the answer to every question is we don't have to worry about it because it's fundamental research. But when you start asking more questions, then it can get very complicated. Well, it's fundamental research, but we've gone beyond that, or we've done, there's all sorts of, well, if you're coloring outside the lines, you're putting yourself and the organization at risk. The important part is on the front end of everything, talk to your experts and make sure you're on the right sheet of music as far as jurisdiction and safeguards, protecting technology. There's one academic institution I'm working with who has a facility that's very much like AGT was, where they're doing EAR controlled and ITAR controlled work in the same facility, and there is no separation between anything. So anybody who walks through that, including foreign students, foreign nationals, visitors, can see anything and everything. You think that might be a problem? Well, ICE thought it was. Sir?
Do you think the fundamental research exemption has been thoroughly tested in the courts?
No. I don't think so. And my biggest complaint about that is people in academia tend to cite it and not really understand what it really means, the breadth and depth of that, and without looking at the stipulations. Because you've got to fit all the stipulations for it to apply. I mean, it's a great tool to have, but you've got to fit the situation.
Well, we work with universities, I could name, that feel that they are above the rules.
Oh, yeah.
And I think we're more adherent to the rules. And it seems to me it would be a very interesting thing to get a real legal ruling on some of the fundamental research exemption.
Well, and we'll talk about it here in a second. I'll get to it in a minute because I want to come back to that because you make a good point about what's happening, what's not happening. Let's see how you're doing on numbers. Anybody have a clue here? What do you think? The question was, the enforcement asked me this. He said, well, you're doing these presentations. How big is the universe you're talking about? So this is probably 6 months old. I just went on the Department of Education site, and at that time, they're claiming there are 6,900 accredited colleges and universities. But several people I've talked to in academia have said, well, it's actually a bigger number than that, because there are other labs, institutions, unaccredited. A lot of people are doing this. So what I've been told is maybe you're talking about 10,000 entities who are somehow involved. I actually think the number that are significantly involved is probably closer to 1,000. But the bigger institutions, and you're a good example of the one thing that's happened over the last probably 5 years, when we're doing outreach, education, and training events, that more and more colleges, universities, and labs and institutions are showing up to get education and training. But it's probably no more than maybe 50, 75 max out of all the stuff I go to. Some schools have gotten it, understand this is a pain in the neck, but you can't afford not to. If you got to figure out a way to do this. Other schools, I'm actually more concerned about maybe even a small school that has one classified ITAR control project. That's all they've got, one government contract. They could be worse than any huge institution. So it's not, I don't know what the number is, I'm just trying to quantify how big we're talking about. But a lot of it's driven by what is your corporate culture? What is the academic culture? How do you view compliance? What kind of education and training do you get? Do you know enough to ask the right questions? How comfortable are you? Or, as a result of today, do you need to ask some questions? Do you need to have, I'm big on process and having a checklist. you know? And maybe when you start a project, whether it's funded or unfunded, maybe if you haven't already got one, there's a checklist that involves them on the front end to make sure you're all on the right sheet of music and don't put yourself and the institution in trouble. All right, let me go on here. We're getting pressed by time. Not an abnormal occurrence in these environments. Now, one of the things I've given you, I started doing these about 8 years ago for those C-level presentations I was talking about. This is a one-page summary. This is sort of everything you need to know about the Roth case. I started doing these because senior leadership does not have, nor do they want to read, a 60, 70, or 80-page settlement document. So what we did at JP Morgan is we came up with this template that kind of got revised over time for high-profile cases. You know, and they're all set up the same, so you can compare one case with the other. But it gives you everything you need to know about what the charges were, what the fines were, some of the nuances, and some web links so you can find more information. Normally I do this as kind of an exercise, but we're hitting all the high points here. In the interest of time, you can certainly take that away. The other thing is if any questions come up, you're certainly welcome to contact me and ask. I may not have the answer, but I can certainly maybe aim you the right direction. All right, so kind of getting to the end here. This is kind of food for thought for you. What do you think? One of the things that intrigues me is the difference I found between what industry thinks Dr. Roth should have gotten and what academia thinks. I had a guy a month ago basically stand up and said Roth did nothing wrong. And oh, by the way, I'm just as arrogant and condescending as Dr. Roth is. I mean, this was, yeah, and he was proud of it, all right? And that, I'm not saying that that's a bad thing, but when you get into this environment and you've done something wrong and you take that attitude, you just got to understand what impression that's going to leave with the guy with the badge and the gun and the ability to put you in jail, or who's under investigation. It changes their perspective rather quickly. So what do you think? Did he get, was it the right, was justice done? Does it make any difference? How does the case sit with you? Does it get your attention? Whatever,
well,
sir.
I think it probably was appropriate. However, he probably got a little bit of a break because of his medical things. And people are going to see that, and they're going to think, well, geez, if I come and say, look, I've got these medical issues or whatever, maybe it won't be so hard on me.
Sure.
I think one of the problems is that you know, the easiest way to avoid getting into trouble is to stop research. We are not required to do research. It's not, you know, we're sort of evaluated, but we can put all our energy in teaching. So what I think that the problem is here is Dr. Roth may have done, had very poor judgment. But the real problem is there's nobody standing up for the interest of the other interests in the U.S. For the positive role that academics and academic research plays. And so I find this a big conundrum because it's, you know, it's raising lots of red flags, but it's not really addressing the real problem that academics have.
Two thoughts for you, too, and you're right on the money there. One thing, a good thing that came out of the Roth case, and that's this Association of University Export Control Officers, was created as a result of the Roth case. And they are now, your counterparts know about them. They are now a very big voice in the government about academia. They're now part of the committees. They're helping speak what needs to be spoken. Now, to translate your earlier thought about, there are companies that I know of personally who have said, we're not going to do that. We're not going to do anything ITAR controlled. Or the other one I've heard, which is easier in industry than it is in academia, is we're just not going to hire any foreign persons or foreign nationals. We're just going to stay away from, I mean, that's a business decision, right? My contention is this is a pain in the neck to do, but it's not too hard to do. You just have to do it right so you don't put yourself and the organization at risk. But there's some challenges that have to be overcome to kind of be on that same sheet of music. So I understand where you're coming from. Sir?
A word which is strikingly missing in the past hour and a half is ethics.
Okay. In what context?
Universities should be the pinnacle of ethical behavior because we're educating future leaders of our nation.
Setting the standards.
Setting the standards. Ethical behavior and legal behavior
kind of go hand in hand, okay? So, is there a follow-on sentence to that?
No, this is one of those questions which is best dangled and thought about later.
Yeah, okay, no sweat. We're planting some seeds. Matt?
I was wondering if you could talk a little bit about the applicability of the principle of fundamental research to the Dr. Roth case and how the line was crossed from fundamental research conceptually into control technology that then was part of the violation.
Well, I don't have specifics other, the key was the documentation and the contractual documents and everything that was set up on the front end that didn't allow, it didn't meet the fundamental research part of the equation. Now, I'd have to delve a whole lot deeper into the specifics.
He was obviously an expert in the field.
Right.
And there was a reason that he was doing the work that he was doing. So I would guess that it was as a result of the direct contract with the U.S. Air Force to take the technology and apply it to the drone.
Right.
That then was where the line was crossed from the fundamental principles of what he was an expert in, and then the applicability then into a military application.
Well, and to me, it's a big part of it is what are the lines drawn in the contract, and I don't know enough about those details. You know, I don't want to speculate at all from that standpoint. Any other thoughts on? Go ahead, sir.
You mentioned that if you're doing an unfunded research project, you still might be under these regulations. My understanding was we operated under a fundamental research exemption, and we could lose that by accepting a contract that has these onerous clauses against publication or other things that come under ITAR or EAR. So are we on an unfunded contract under ITAR or EAR?
Well, where you would be subject to export controls.
Use the microphone, and it's really hard to hear you.
Okay, you would be subject to export
It's still
controls
off, I think.
with regard to, can you hear me? Okay, if you were in an activity where you were traveling to an embargoed country and you were taking equipment out in the field, and maybe that equipment is controlled. You're working with laboratory equipment that is controlled, and that you were exporting it, taking it out of the country. You're subject to export controls under the Department of Treasury if you are working with a country it has sanctions, U.S. sanctions against it. So there are instances where you would be outside of the actual research, but the fundamental research exclusion does not apply to shipping or actually taking hardware and software out of the country. You no longer are covered by the fundamental research exclusion. I know that there's probably...
Well, to answer your questions, and I'll just allude to some other example. Other institutions have a process in place to evaluate both unfunded and funded research. Okay, the rules, the government regulations apply to both, right?
Yes.
So you've got to have a way to do that, because I found it interesting at a couple of schools that they hadn't even thought about the unfunded side at all. To say, oh, we didn't think about that possibility.
The only thing I would say about that is that even if it's unfunded, the term contract is what you're looking at, because there's still a quid pro quo somewhere. Whether you're sharing information, agreeing to share information, even a non-disclosure agreement is subject to export regulations based on what you're sharing and who you're sharing it with.
So does that mean there's some indication, even in unfunded work, to be able to?
It doesn't matter, because you can still be sharing intellectual property.
Right.
You can still be bringing share research results. It's just that the quid pro quo is something else other than dollars. That's the only difference.
Sure.
Well, I think what you got to do is just draw a line and say that if you're not sure, ask, because there's no such thing as a dumb question.
Absolutely.
And then follow that up with loose lips, sink ships. So if you're not, a lot of people get in trouble by making statements that they shouldn't make, thinking that they're not harmful, and they become harmful.
Yeah, and I'm a big supporter of your when in doubt, ask. Yeah. If the one thing, if I'd have listened to my gut in my entire life, I would have been far better off than I am right now. Every one of us has some kind. When you're involved in something and you're going, wait a minute, doesn't smell right, doesn't look right. Well, all right, what do you do then? Do you ask more questions and feel comfortable, or you just sort of go, oh, well, not my problem, somebody else's issue? So, sir.
John, the question I often give people is, in terms of your first thought about consequences, if we
we think in terms of the punishment should be proportional to the crime. It's clear the consequences were to Roth. What were the consequences to national security, for example, of his disclosure? At point one. And point two, what are the unintended consequences? I think this goes back to the issue earlier of what are the benefits of actually sharing information broadly? And I think the perception is that the regulators often overemphasize the difference between two hydraulic high-pressure lines that are meaningless, and forget the positive consequences of collaborative research.
Well, I'll answer part of that. In fact, the next slide talks about some of that, because the other positive outgrowth of Roth is the enforcement community is now a little bit more sensitized to connect with academic institutions so they better understand some of those kinds of issues and how to work with you better. So the stupid part of this equation is some of this stuff we're controlling, right? Anybody have any question about some of the things that we have done, and we're not only inhibiting colleges and universities, we're inhibiting our own business people internationally because they can get the same thing from somebody else a lot easier and a lot cheaper. The good news is, and you've got agents both in Homeland Security and FBI right here in Denver who have a dialogue with you and are more than willing. I'm a big advocate of education and training by diverse means. I'm giving you kind of a perspective between the real world enforcement and some of the things you need to be aware of. But I guarantee you, if an FBI agent or an ICE agent comes here and does a presentation, the flavor is going to be different, much different than my view of the world. But you really need to be tuned in to what's at stake here. But there's resources that you can help each other. And I was convinced yesterday in talking to the keynote speaker, who's the senior agent in charge of the Homeland Security office here, and his agents, they really want to be, they see this as a partnership. But part of their problem is they don't understand what you're doing any more than perhaps you understand what some of their obligations are. So kind of talking to each other and educating each other. And maybe some of that can be a voice besides the association to get back to the government to say, why are we doing this? Because the Association of University Export Control Officers, they've had some dramatic impact on changing some things that were going on with export control reform that I'm convinced wouldn't have happened without their voice. So that's a way to deliver the message. Yes, ma'am.
Well, and one of the things that we get really concerned about is mission creep. These ideas of saying it's not classified but sensitive and trying to control things that are not controlled.
Right.
And so we really want to not, that's really what the mission of that group would be,
Right.
is to try to push back on the idea of controlling things that shouldn't.
Well, and what you're doing is on the leading edge of technology, right? That's part of the purpose of being there. It goes back to the question about checking denied parties list more than once. Well, if you're involved in a research project, well, it's not static, right? You may discover new stuff, and there may be, well, wait a minute, we need to go back to Linda and her team and say, wait a minute, maybe the jurisdiction has changed, maybe something's happened here where we need some expert advice to make sure we're still abiding by the letter and spirit of the law. It's dynamic, you're absolutely correct. Not much in this world is a one-time only, and particularly when you talk trade compliance and regulations that have changed and are changing more. It's the magnitude of what we're talking about with all this stuff moving from the State Department to the Commerce Department, the implications are huge. And most of industry doesn't really understand it either. But it certainly impacts you, but to a different degree. Other comments on slides, et cetera? We're sort of past time, but I think there's one more. Oh, yes. This is one of my favorites. Linda saw this yesterday. Anybody who's seen me before has seen this. What do these entities have in common? This isn't in your package, by the way. Yeah. Okay, now, what do you see here? Are there big companies? Are there small companies? Is it government? Is it dual use? Is it munitions? Yeah, it is. Well, everybody, right? Look at Morton Salt, Bayer Aspirin, okay? Any government entities on here who are part of the problem?
All of them.
Okay. What about Lawrence Livermore, all right? What about Sandia, all right? All right, same problem. And the reason I use this slide is, okay, let's say you happen to be a big company or a big academic institution. Does that guarantee you're going to get this right? Okay? Boeing, right? Boeing a big company? You think Boeing has a lot of people working export controls and trade compliance? Yes. But guess what? In the last 12 years, Boeing has settled 5 times with the US Department of State, okay, for almost 600 alleged violations and over $62.5 million in fines. All right? Wait a minute. How can that be? Well, Boeing is a huge organization, decentralized, and what Boeing didn't do for many years is the right hand didn't talk to the left hand. One business unit made a mistake, and they were very, well, we can't embarrass Sally and Tom, and we're not going to pass that information to the other institution or other lab or somebody else just because we don't want to embarrass anybody. So Boeing wasn't looking at processes. They weren't looking across the company. Information wasn't flowing across the company, so they continued to violate. The key to this slide is you don't want to be here. The good news is for academia, do you see any universities or colleges? Not one, right? Not yet. Right? The goal, the goal from an institutional standpoint is to not be on this slide. And if you happen to be an entity that is a repeat offender, you got to learn from your mistakes, and you got to get over the self-righteous, I can't embarrass my counterparts. The government assumes that if the University of Colorado at Boulder has a compliance program, the compliance program goes across the University of Colorado at Boulder, and everybody's doing the right thing. The education, the training's there. You're taking the steps to ensure compliance. All right, this is kind of a final exam. Now part of this you ought to figure out from the earlier discussion, right? You already know there's at least 3 definitions of exports, right? There's 2 in commerce, deemed exports and exports. There's 1 in state. Well, this happened like 3 years ago. The government was analyzing export control reform with these 40-some different agencies, and they discovered, guess what? There are 8 different definitions of exports, right? And who gets to figure out the differences and the nuances? Whose responsibility is that? Ah, it's yours, right? The State Department's perfectly happy with their definition, right? So if you're doing work with multiple agencies or multiple government agencies, it might be of interest to you to find out what their definition of exports is, right? And I know you're working contractually with a bunch of different government agencies, so you want to make sure you're on the same sheet of music with them about what the definitions are and what your regulatory obligations are under both the EAR and ITAR. And that's it. I will stick around. We're on a tight schedule, but 10 minutes if anybody wants any questions afterwards, or if anybody has any burning hypothetical question for the group. Thank you for your time.